4 out of 16. That's the number I keep coming back to. Not 16 children removed from a home in Vinton County. You already know that part, if you've followed this case at all. 4 birth certificates out of 16 kids. That's what investigators actually have confirmed on paper months into this case. I want to sit with that gap for a second, because I think it gets lost in everything louder happening around this story. So today, I want to talk about DNA, not in the way you've probably heard it discussed, as some dramatic mystery-solving device, the way it usually shows up in true crime coverage. I want to talk about what it's actually being used for here, legally, and why that use is more procedural, more administrative, and honestly, more revealing about how this case has been built than most coverage has made it seem. If you followed this case, you know the outline already. 16 children removed from a home in Hamden, Ohio, back in June. 4 adults facing felony child endangerment charges: Gary Siders Jr., Elizabeth Siders, and Gary Sr. and Christina, the grandparents. I'm not going to walk you through all of that again today. What I want to focus on is narrower, and I think it's a piece of this case that explains something the headlines haven't quite captured. Let's start with what Vinton County's own prosecutor actually said, because I think his exact words matter more than any summary of them would. William Archer, at a press conference in early July, was asked directly whether all 16 children had birth certificates on file, whether they were formally registered with the state at all. He didn't confirm it. He said plainly that he couldn't provide those details. And later, when pressed further on that same question, he said something I don't think got the attention it deserved. He said he doesn't know that they have all of the birth certificates. That's the county prosecutor, not a commentator, not someone speculating online, piecing together theories from public records. The actual person building this case, saying, on the record, at a press conference, that the basic paperwork establishing legal custody and responsibility might not fully exist for every child involved. I want to be precise about what that does and doesn't mean, because I think it's easy to read something dramatic into an administrative gap like this one, and I don't want to do that. It doesn't tell us anything about what happened inside that home. What it tells us is narrower and honestly more mundane than it might sound at first listen. That the formal, legal paperwork connecting each child to the adults responsible for them, the kind of paperwork that exists automatically for almost every child born in an American hospital, appears to be incomplete for a meaningful portion of this specific family. Here's what investigators have actually confirmed, according to reporting from NewsNation's regional affiliates, WOWC and WCMH. They obtained birth records for 4 of the 16 children, including the oldest, and those 4 records list Elizabeth Siders and Gary Siders Jr. as the listed parents. 4 records, confirmed, on paper, in official documentation. For the remaining 12, there's simply no public confirmation either way. I want to be careful about that distinction, because it's easy to blur. It's not that anything has been disputed, or that investigators have found records contradicting who these children's parents are. It's that the documentation that would normally settle the question hasn't surfaced publicly yet, or, in some cases, may simply not exist in the way people assume it automatically would. I keep thinking about what that actually looks like in practice, honestly. A household where, over the better part of 2 decades, children arrived, grew, presumably needed medical attention at various points, presumably existed in the world in some basic capacity. And yet, the most ordinary administrative record of who they are, legally, in relation to the adults around them, is incomplete for most of them. Not necessarily hidden. Possibly, in a lot of these cases, simply never generated in the first place. This is where DNA testing actually enters this case, and I think understanding its real function here is more useful than treating it like a plot device. DNA testing is currently underway on all 16 children, that's confirmed. And the instinct, hearing that, tends to be assuming it's about solving some hidden mystery, identifying an unknown culprit, uncovering something concealed through genetic detective work. That's not really what's happening here, Or at least it's not the primary function of it in this specific legal context. What DNA testing actually does procedurally in a case shaped like this one is establish something foundational that almost every other custody or criminal case involving children gets to skip entirely, because ordinary paperwork already answers it. Who is legally responsible for this specific child? Who holds parental rights? Who, precisely, is being charged with endangering which specific child, and on what documented legal basis? Think about what a prosecutor actually has to assemble here, structurally, to bring this case to trial. Elizabeth Siders is facing 17 counts, one more than the other 3 defendants, each of whom face 16. The exact reason for that 17th charge hasn't been publicly disclosed, and I'm not going to speculate about it. But setting that specific detail aside, prosecutors building a child endangerment case connected to 16 separate children need documentation establishing, individually, for each child, which adults actually held legal custodial responsibility. That's not paperwork for paperwork's sake. That's the legal foundation the entire prosecution has to stand on once this reaches a courtroom. In an ordinary case, a family with 2 or 3 children, standard hospital births, standard follow-up paperwork, that foundation exists automatically. Nobody needs a laboratory. A birth certificate settles the question, full stop, the same way it does for virtually every family in this country. Here, for a significant number of these 16 children, that foundation doesn't currently exist in confirmed, documented form, which means prosecutors are, in a very real, practical sense, having to establish some of the most basic legal groundwork of this entire case using lab results, simply because the ordinary paper trail that would normally do that work isn't there to rely on. I think that's genuinely worth sitting with for a moment, separate from anything else about this case. 16 children, and for most of them, the state doesn't currently have confirmed documentation of who holds legal parental responsibility. Let's talk about why a gap like that might actually exist, because I think it connects to something specific in this family's documented history, rather than being some unexplained, separate mystery sitting on top of everything else. Elizabeth Siders and Gary Siders Jr. were married on March 31st, 2008, in Mason County, West Virginia. Court records confirm she was a minor at the time, married with parental consent, and that both she and Gary Jr. had limited formal education, having completed schooling only through around the 9th grade. The couple were reportedly living in Gallipolis, Ohio, on the same residential street prior to that marriage. I want to be careful here because I don't think it's my place to speculate about the internal dynamics of that household beyond what's actually documented in the public record. What I think is fair to observe, plainly and without embellishment, is this: a household that began under those specific, limited circumstances, without extensive formal education or institutional familiarity, isn't necessarily one that would have had consistent, ongoing access to the kind of administrative systems that generate this specific kind of paperwork automatically. Hospitals with full follow-through on documentation, pediatric practices that maintain consistent records over years, stable addresses tied reliably to a single school district, generating enrollment paperwork alongside medical paperwork. That's context for how a gap like this could plausibly form gradually over the better part of 2 decades, without anyone outside that household ever fully noticing it was happening. It's not an excuse for anything. It's simply an explanation for the mechanism. I want to bring in something else here, because it's one of the few places in this entire case where the public documentary record is unusually clear, and I think that clarity is worth noting specifically. Twin infants, Faith and Bailey Siders, were born in November of 2022. Records confirm they were born very prematurely and did not survive. Their deaths, according to records reviewed by NBC4, were attributed to natural causes, and both their births and their deaths were formally documented at a major hospital system. I mention this specifically because it demonstrates something important about the shape of this documentation gap. It isn't total. This family clearly did have real, direct contact with formal medical institutions at certain points over the years, contact significant enough to generate complete, verifiable records for 2 of the youngest children, even under the most difficult circumstances imaginable, which makes the incompleteness of records for a majority of the 16 surviving children a genuine, open procedural question, rather than something easily explained away by assuming this family had 0 contact with any formal institution ever across 2 decades. I keep turning that specific contrast over in my head, honestly. 2 children, documented completely, from birth through death, at a hospital system with full institutional follow-through, and a larger number of their surviving siblings, without that same confirmed documentation trail establishing even the most basic legal facts about their parentage. Let's talk briefly about how officials have publicly chosen to characterize this case, because I think the specific language they've selected is doing real, deliberate work, even if it's easy to read past quickly. Officials have described this as an intra-family case. That's the actual term used publicly by the Attorney General's office, and it's worth understanding precisely, rather than assuming its meaning. I want to be careful about what that word is and isn't doing here, because I think it's genuinely easy to overinterpret a single piece of prosecutorial terminology. In standard legal and law enforcement usage, intra-family generally signals that officials believe the conduct being investigated occurred within an existing family structure, as opposed to involving an outside party, a stranger, or some external threat entering the household from beyond it. That's the term's ordinary technical function in a case like this. It's a classification describing where investigators believe the relevant conduct originated. It isn't on its own a specific factual claim about anything beyond that basic distinction. I want to be honest about where all of this actually leaves us, because I don't think this particular thread of the story resolves into anything tidy. And I'm not going to pretend otherwise, just to give this video a cleaner ending than the facts currently support. We don't know what the remaining DNA results are ultimately going to show. Nobody outside the investigation does, and speculating about specific outcomes beyond what's already been confirmed publicly wouldn't be responsible, so I'm not going to do that here. What we do know, confirmed directly from the prosecutor's own public statements, is that a meaningful portion of the standard legal paperwork this case would ordinarily rely on simply isn't currently available, and that prosecutors are actively using genetic testing to help establish that specific administrative and legal foundation as they prepare formal charges heading into the grand jury process. I think it's worth stepping back for a moment and considering just how unusual that actually is, within the broader context of how the American legal system typically handles cases involving children. Birth certificates exist precisely so that questions like this one never have to reach a courtroom in the first place. They're meant to be settled, automatically, quietly, the moment a child is born, through routine hospital administration that most of us never think about twice. The fact that a state prosecutor's office has had to turn to a genetics laboratory just to establish who holds legal responsibility for the majority of 16 children tells you something meaningful about how far outside those ordinary administrative structures this specific family existed for a very long time without anyone external ever fully documenting it. All 4 adults facing charges in this case have pleaded not guilty. The grand jury process remains ongoing, and based on public reporting, is expected to move forward in the coming weeks. Nothing about the documentation gap we've discussed today constitutes evidence of guilt for anyone specifically. It's a separate, procedural, administrative question running in parallel to the criminal case itself, and I think it's important, journalistically, to keep those 2 threads distinct from one another, rather than allowing one to be read as evidence for the other, simply because they exist within the same broader story. We'll keep following this case as the DNA results, and the broader legal process surrounding it, continue to develop. And when there's confirmed information about what those specific results actually show, we'll bring it to you directly. Not speculation dressed up as revelation, and not a theory built to fill a gap the actual documentation hasn't closed yet. Just what the paperwork and the science behind it actually end up confirming once it's confirmed.